Congratulations to Jonathan and also Dave and Mike and all the organizers. It's been fantastic. And I think that's going to continue with this panel where we talk about funding legal processes. If this is a topic that interests you, then you probably already know the panelists who are up here and know that we're in for a great talk. If this is not a subject that interests you, then I would say the same thing I said to my girlfriend before she became my wife, which was, let's just give it a try. I promise it won't be boring. The format will be this. We're going to kick off with hearing from Sean Coffey, who's going to sketch out what we mean when we talk about different ways of funding legal processes and litigation specifically. And then we're just going to have a discussion, the four of us up here. I've got a few questions here, and hopefully you have some questions too. I think the scheduled end time for this panel was 4:15. We'll probably run a little bit more than that. But in any event, hopefully it will be a lively conversation. So. Can we get Sean's PowerPoint, or is it already?
Well, while it's coming up, good afternoon, everyone. It's a pleasure to be here. Just a quick background. I have been a large firm litigation partner. I've been a plaintiff's lawyer, and I have also been in the lit funding business. And I'm now back to being a litigator. But I'm a big believer in the space, commercial litigation finance. And what I'm going to do to kick us off is give you sort of a primer, the basics, and then we'll be talking about aspects of what CLF, as I like to call it, can do for companies, for law firms, et cetera. So with that, what is commercial litigation finance, or any litigation finance? It's a transaction that gives a third party, other than a lawyer, a financial stake in the outcome of a legal dispute in exchange for cash paid to a party to that dispute. Now, you know, litigation finance is both relatively new and it's also very old. If you take out that parenthetical, what you're looking at is the contingency fee model that's been around for 100 years. So commercial litigation finance, the idea that a client can bring a case without actually laying out money or offloading risk, if you will, and cost to someone else has been around for 100 years. But it's been in the exclusive domain of a very narrow section of the bar, the plaintiff's contingency fee bar, which, I'm here to tell you as a former plaintiff's lawyer, the rumors are that they make a lot of money, and those rumors are true. And it's in part because of this incredible inefficiency that the plaintiff's bar is able to exploit. I'm now a partner at Kramer, Levin, and my conversations with my clients are typically, how much of a discount off my hourly rate will I give them? When I was a partner at Bernstein, Litowitz, Berger, and Grossman, we looked at cases to see how many times my hourly rate will I make on this case. I don't think I'm a worse lawyer than I was a few years ago, but there is this real disconnect. And what's exciting about commercial litigation finance is it's an opportunity to exploit that inefficiency for the benefit of clients who might otherwise have to pay more to plaintiffs' lawyers, for society, I would say, because it allows David to fight Goliath on a more level playing field, and it's just a market solution. So it's old and it's also new. It's also a good investment, by the way. I think investors are starting to figure that out. So first, there are basically three types of litigation finance. Consumer. We're not going to talk about consumer very much today. Am I on the right?
Yeah, one more.
Okay.
Oh, no.
All right. Sorry about this. There are three types. There's consumer. This is forward. Got it. There we go. Thank you. There's consumer, which is more like the personal injury. You might have heard of some of these outfits, 1-800-LAW-CASH or something like that. And it's more of an actuarial play where they put a lot of money out a little at a time. You know, I think their average is something like $1,700 a case, and it's primarily a loan. There's also law firm lending, where a funder might loan a law firm a chunk of cash and have as collateral its docket. And then there's commercial litigation finance, which is more of a one-off, case-by-case basis, lots of underwriting, and I think that's where we'll primarily spend our time today. With regard to commercial litigation finance, I thought I'd give you some of the criteria that goes with the typical transaction. The cash that's given to the company, and that's typically how it works. The funder will provide funding for the company, it's usually couched as an equity investment as opposed to a loan. And what's happening is the funder is buying a piece of this claim. It's usually non-recourse, meaning while the only recourse for the investment is the cause of action, is the lawsuit, and that if they lose the lawsuit, they can't turn around and ask the company for the money. Very important. The contract is between the funder typically and the company as opposed to the law firm. This is important for purposes of independence and judgment and fee splitting and things of that nature. This investment range can vary widely, but it can be as little as a few $100,000, or it can be very significant. It can be doled out as a lump sum in the beginning or drip fed over the course of the case. One thing that's very significant that's different between consumer and commercial is that just about every deal in the commercial context, the client, the corporation that's taking the investment, is a sophisticated consumer of legal services. So, the U.S. Chamber of Commerce likes to attack litigation finance as somehow exploiting the fundee, as it were. But again, these are folks who are very sophisticated, and the money can be used either to pay the litigation fee as it goes, or it could be that some entity wants to take money off the table now and use it to build a factory or for some other corporate purpose. They have an asset It's an unliquidated litigation claim, and they're basically willing to take $1 today that they can use today in return for giving the funder $4 or $5 down the road. That may or may not actually happen. Very important, funders typically do not give legal advice. Even though they're frequently ex-lawyers and understand the legal system, they are not giving advice. They're businessmen. I'll go through these very quickly because I know we have a lot to say in a little bit of time, but there are funding advantages for companies. They can pursue claims they might not otherwise be able to do, and they can hire the law firm. The basic deal, there's sort of two models. There's the old model, current model too, of paying by the hour, which clients don't like because the lawyers don't have any risk. And then there's the contingency fee, which a lot of companies don't like because they have to hire plaintiffs' lawyers, and they don't like them. Commercial litigation finance offers a way to bridge the gap. You offload the risk and the cost to a third party, funder, and you use the money that you get to hire the law firm by the hour that you like. For law firms, it's also an advantage because there might be cases brought that might otherwise be brought. They'll get paid regularly. They get a cross-check on the merits of the case. And the last thing I'll say before I stop, it's very, very important to understand that there are a whole bunch of rules that could apply and do apply to commercial litigation finance. There's statutory rules. There are some states in our country where it's illegal to do what lit funders do. It's a crime in Mississippi. That's tied to the civil rights era and trying to keep people from helping the NAACP, but it's still on the books. You have court rules. In some jurisdictions, you have to disclose all the parties with an interest in the case, okay? Query, do you have to disclose the existence of the funder? And then you have the ethical rules in the state by state. What are the lawyer's responsibilities vis-a-vis the client if a funder's involved? Certainly not going to go through those, just flag them. For every investment in each of our 51 jurisdictions, you have to figure out all of those rules and how they interact with each other. So it's complicated, but it's very exciting. It's a terrific new area, and now I'll turn it over to someone who's actually still doing it, and doing it well. Travis.
Well, still doing it anyway. Thank you very much. My name's Travis Lenkner. It's a pleasure to be here with you this afternoon. Thanks to Steve, who's a colleague of my wife's at Northwestern University on the faculty at the law school, and to everyone who had a hand in organizing today. I did want to say I was sorry for not being here for the rest of the day's sessions. I flew in from Chicago today. So I spent a little time at LaGuardia, which is appropriately Dickensian. So you have a Bleak House theme, and that's the only real link that I have for you. But the D gates are grim, and I was there. I'm a managing director at a litigation finance fund called Gerchen Keller Capital, based in Chicago. We launched at the beginning of 2013, and as of today have a little over $300 million in assets under management. Those assets are dedicated to commercial litigation funding arrangements of the sort that Sean described. By commercial litigation, we mean business-to-business litigation with a corporate entity on the plaintiff's side as well as the defendant's side. and we mean a situation where our counterparty, usually the company, but occasionally the law firm, is a sophisticated organization and someone with experience in the litigation space. Our average investment size is somewhere between $3 and $7 million, and those funds typically are used to pay for legal expenses, so attorney's fees and/or out-of-pocket costs like expert witnesses and e-discovery vendors and things of that sort. But sometimes, excuse me, as Sean mentioned, those dollars can also be used as working capital for the company or the law firm. And they are non-recourse or limited recourse arrangements where generally our recovery is premised on a successful outcome in the litigation. One other quick thing to mention is that we are interested in funding on the defense side as well as on the plaintiff side. So our view is as actually positioning ourselves and others in this space as financial services providers to companies and law firms that are involved in commercial litigation, whether they are a plaintiff or a defendant. To expand just a little bit and then turn it over to Chris and hopefully have an engaging discussion here and with your questions, but to expand just a little bit on the value propositions of commercial litigation funding, both for companies and also for law firms that become involved in these sorts of transactions. First of all, just very quickly on the company side, the basic, very basic way to categorize the companies that might be interested in commercial litigation funding is just to split up companies and call some of them small and the rest of them large. So from the small company perspective, it's fairly easy to see what the incentives might be to look around for commercial litigation funding alternatives. You have a well-financed defendant that is capable of going the distance and is going to hire an AmLaw 5, 10, 15, or 100 firm to punish you in discovery and take you as far down the litigation road as they can. And so it's necessary to find a firm that is suitably equipped to match them on the plaintiff's side. It may not always be the case that you can find a firm that would take your engagement on a contingent fee, or that the firm you want to work with is a firm that offers contingent fee sorts of arrangements. So as a small company, you might need to pledge some of the contingent receivables in the litigation in exchange for finding counsel in the first place to represent you. As a large company, you might say these are companies in some cases with billions of dollars in cash on their books. Why on earth would they give up a portion of their potential recovery if they were a plaintiff in a commercial litigation matter? The short answer is there are actually a lot of reasons that they would, and I'll mention two. One is quite simply that the larger the organization, the more internal agency issues present themselves, and so the litigation budget or the law department budget is what it is, full stop. And for a company with $2 billion in cash, but $50 million to spend on litigation or legal services in a given year, most of that $50 million is already spoken for in fighting wars of necessity, that is, defending the company against litigation in matters where it has to defend itself, as opposed to fighting wars of choice on the plaintiff side. So very frequently a general counsel and almost more frequently a chief financial officer might say, gosh, instead of spending another $5 million to bring this action, which we might not win, and so that might be $5 million that just hit the P&Ls and we lose that money forever. Perhaps we should go and get the counsel we would have anyway, and because they don't want to offer a full contingency, we'll give up the standard 35% that we would be giving up if we did have a contingent fee law firm. We get to work with our counsel of choice, and we're no dollars out the door to bring this piece of litigation. If we win, it's found money, and if we lose, we aren't out anything. We haven't spent corporate assets above and beyond the legal budget to go and bring this claim. The other quick incentive for large companies is more of an accounting issue, and Sean alluded to it. If you have a litigation claim, you have an unrecognized or unliquidated asset that doesn't actually show up on the books. You just have a claim. If you, by contrast, have a coal mine, you can go and buy a lot of earth-moving equipment to move the dirt and get the coal and extract it and sell it. And those are capital expenditures. There are lots of accounting and tax incentives for buying all of that heavy equipment. The same incentives don't apply when you go out and hire Cravath to bring a piece of litigation on your behalf. Every dollar out the door to pay the law firm immediately hits the P&Ls. It affects quarterly earnings, and Wall Street pays attention if you blow that number by even a penny, and they don't care if your excuse is, well, we were chasing $100 million in a breach of contract case that we think we might win in 4 years. It's actually a pretty bad answer if that's the situation in which you find yourself. So frequently companies, even large companies, will look to funding arrangements to solve that sort of issue. And then just very quickly to speak to law firm incentives, the whole theme of today is to look at lots of different ways, and funding being just one of them, where entrepreneurial lawyers are changing the space for the better. And for some of the folks that we talk to, I will just say that entrepreneurial means finding more people who want to pay you by the hour using the same model we've used for a really long time. That's not the way we think of it, but that's the way some other people think of it. And so one incentive for law firms is if they are looking to take a bit more risk than they might take today. So a firm that frequently represents corporate defendants, very rarely takes plaintiff side engagements, but also almost never takes contingent fee matters on the plaintiff side. They might say, well, we're interested in taking a small portfolio of contingent fee cases because our clients are demanding these alternative fee arrangements. We don't know what that means, but we'd like to figure it out and try to meet those demands. They can partner with a funder who will come in and underwrite a case and share the risk with them in order to give the client a risk-free engagement on the plaintiff side. That is, the client is out no dollars today, but the law firm is getting some money in the door every month in exchange for its time. So the firm is basically able to give the client a full contingency, while the firm can basically see it as a 50 or 40 or 30% discount, with the funder taking an equal or possibly larger share of the risk and allowing the firm to have some revenue during the time when it's paying salaries and other costs to actually bring the case. So that was supposed to be very quick, and it wasn't, but that's a short picture of some of the incentives that we see in the market, and I'll turn it over to Chris.
Hi, so I may well be the odd man out here. For a little background, I am a third-year law student here at Brooklyn, and I coordinate the Patent Troll Defense Network, which is administered by the App Developers Alliance, a trade association out of DC. So a lot of my work is involved on sort of the alternative means and methods with which people raise funds for litigation. Patent troll defense is it's a very asymmetric system wherein costs are high for both parties, but costs are generally higher for defendants than plaintiffs. And many times defendants are, as you mentioned, smaller businesses, unless we're dealing with, at least the ones I deal with. We're not talking the Googles and Apples of the world. I'm talking usually single inventors or small startups in the app space. And so a lot of them can't afford to go through the actual process of litigation and need to find some means to finance that. There are your sort of standard well-developed means, and then there are newer ones like the most recent sort of equity investment process the SEC has been talking about recently, equity crowdfunding, and then your various legal defense funds. So that's sort of what I work in. I'll keep that to there, and we can actually maybe have a discussion or take some questions too while we have time.
Okay, great. So if there are any questions at this stage, we can. I've got several.
Looks like we've got a bunch, but while I walk to people who have questions, I'm going to take Travis to task. Didn't you know what happened to Joe Biden when he slandered our beloved LaGuardia Airport? We're going to have you bound and gagged and shoved in the trunk of a Buick before you leave this place.
The flight is already delayed an hour home, so I'm paying for it, even though, yes.
So what level of control or input do the loan providers or the fund providers have over law firm selection, like guidance to the client? Like what sort of impact do you have?
Great question. And the answer is it depends. But when lit finance first started, it really started in Australia, other than, we're talking about commercial litigation finance, but Australia, then it spread to the UK, where it's very well developed, and it's been here 5 or 6 years. And it was very conservative. In fact, they touted themselves saying, we have nothing, hands off, totally hands off. What at BlackRobe, my former outfit, we call the passive approach, or lit finance 1.0. It's different now. I think folks are more comfortable with it, and the ABA Commission 2020 on ethics came out with an opinion a couple of years ago. It was very helpful. And if you think of a lawsuit, of a litigation claim as a bundle of sticks, and each stick is a right. You have the right to pick counsel, fire counsel, be informed about what's going on, settle the case, bring the case, et cetera. If you think of it as a bundle of rights, and I'm converting what the ABA said into something, as a trial lawyer, I think I can convey. The ABA basically said you can sell one or all of those rights to someone else for consideration. And so you can sell to a funder the right to control the case. Okay? You can't do that with a lawyer, because a lawyer has ethical prohibitions against that. But a funder, you can. And so it depends on what you bargain for. And let me use another example. No one would have a problem with the following. I own a company, I have 100 shares. I have one asset, my litigation claim against Acme. All right, I could use some money now. This is a great claim, but I could use some money now. So I go to Travis and I say, Travis, I want to sell you 33 of my shares. Okay, I still control the company, but Travis says, you know, the only asset you have is this fund, this claim, so I'll give you the money for 33 shares, but I want the right to bracket settlement or control settlement. No one would have a problem with that deal, okay? Because it's, you know, I'm able to sell. And the ABA basically endorsed that approach. And so you can't do it with a law firm, et cetera. The reason you want to be in privity with the client and not the law firm is because of things like independence issues. Is a law firm doing this because they need to please the funder or the client? And so it depends on case-to-case basis. Maybe Travis has experience, but what you're doing in this business is assessing risk. And from my perspective, you reduce risk if you can actually have a say on settlement. And you just end up paying for it.
So I'll just say that Sean's exactly right. There's a pretty wide spectrum, both of what's permissible and of what people believe is permissible. I think that's fair to say. As a matter of conservatism, and also the fact that we tend to limit ourselves to larger dollar commercial cases, we still follow the philosophy of passive capital. So we have information sharing rights. We look like a non-testifying expert or a litigation consultant in the sense of being on the sidelines, having a voice in strategy, having the right to know about a settlement offer before a decision is made, but not having any contractual right to say, you must take this, you cannot take this settlement, you must make this argument, you must raise this claim, et cetera. So from our perspective, then you mentioned counsel, diligence on the front end is incredibly important, not just about the quality of the claim, but also the quality of the lawyering, who will be primarily responsible for the case, the background of the firm, and so forth. But we take a passive approach.
So do you get situations where a particular funder will have a good relationship with a particular firm, having worked with them on a few different litigations, and build up that kind of trust, or not really?
Sure. I mean, BlackRobe was around for about 2 years, and it's no longer around or active for a number of reasons that have nothing to do with the space, just more startup personality issues. But certainly, when I started it, I know a lot of folks in town and visited with them and know good lawyers, and they were there's a lot of interest because the big firm model has issues, challenges, it may be broken, and so there's a lot of interest in this alternative to maybe goose profits. I've been back in the big firm practice now for 4 months, and I've had already three terrible conversations with clients about our bills, and I remember how I hated this. And so if I was able to say to a client, listen, your legal budget is zero, because I had a funder backing us in a law firm lending context, it would be I could see the attraction of it. So anyway, Travis.
No, I think we primarily see inbound opportunities from law firms, not from companies, not because our counterparty ultimately is the law firm, but because the attorneys are just working with the client to find solutions to allow the litigation to continue or for whatever reason. So it frequently is the case, much as it is with your IT providers and your demonstrative graphics providers and all the other service providers that law firms use. They're fairly sticky, and particularly in this new and emerging space, they want to have a good understanding of who they're working with and who they're introducing to their clients. So yes, to the extent we can develop good and deep relationships with law firms, that's a great thing.
Yeah, one thing that the ABA Commission paper I referred to before from February of 2012 does flag as a potential issue an ongoing close relationship between a funder and a law firm as something that could give rise to some independence issues. Just FYI.
That's my question. I've been doing this for 38 years, and on my cynical days, I don't care to take advice from an organization of prostitutes. So the ethical restrictions on private investment in law firms really don't move me particularly. In the UK, they apparently don't move them enough so that it's allowed. You can now privately invest in law firms over there. So I don't understand why we don't do it here.
Yeah, you lost me after the word prostitutes. I'm still.
I got distracted.
I know there are certainly differences. In the UK, law firms are solicitors are required to tell their clients about the availability of lit finance. And here, we're still, or you are still pushing to get it more widely accepted. I think part of the Ethics 2020, to get right back to your point, there was a parallel effort to talk about allowing investment in law firms. The paper on lit finance made it through and was published. The one on allowing investment in law firms was strangled in the crib, as it were, and never saw the light of day. So it's just a really, really sensitive issue among the bar, or the powers that be in the bar, and so it didn't even get out of committee, or it didn't get out of the process.
I guess I would say if you come at this space as we do, my partners and my backgrounds are all from law firms that traditionally represent companies on the defense side. And by saying we're only doing commercial litigation, the way we define commercial litigation finance is to say on the plaintiff's side we aren't funding consumer class actions, products liabilities, securities fraud, a lot of the types of cases that are partly or largely responsible for a reputation of the plaintiff's bar, if you put that term in quotes. One inequality that persists because of the rules about non-lawyer ownership in law firms is that lawyers on the plaintiff's side who have been very successful or have hit it big in a couple of cases, legitimate or not, now have a very large war chest that they can use to perpetuate whatever sorts of suits they might want to bring against corporate defendants. So from the point of view of the people who turn to us for funding, it is frequently small and mid-sized companies. Those sorts of plaintiffs' lawyers aren't the plaintiffs' lawyers who would be representing these companies in their disputes, but these companies need financing solutions and ways that they can have access to the courts, where they're basically caught in the middle of a spectrum with pure contingency fee trial lawyers with millions of dollars of personal wealth that they can now use to bring new cases on the one end, and AmLaw 100 law firms that only charge by the hour and are very expensive on the other end. And a lot of the companies we work with sit right in the middle. So the funding that we provide is partly a solution to an access issue for them that is created somewhat because there is not non-lawyer ownership in firms that would allow firms themselves to stake companies like this and bring in those sorts of cases. And I know for the people and companies that Chris works with, I think it's a very similar profile.
Yeah, building from that, on the defense side of it, there are many entities and corporations that we work with that are so small that maybe their only assets are a single patent or their invention or their creation or not a provisional patent, which is not really anything, and would not otherwise, aside from whether it be a standard or an alternative means of lit funding, they would not be able to defend their claim, would have to settle, enter into a forced license, or shutter their business, or all of the above. So by having this as a viable option, it allows cases that otherwise would have gone unheard to at least reach trial stage.
Yeah, one thing we looked at with regard to patent cases for small inventors, and I don't know if you've considered this, is, okay, typically a funder is looking, at the end of the day, there's a pot of money that's achieved through the litigation and through settlement, and they'll get a piece of it. So for a small company that fends off a troll, you know, what's in it for the funder? And I think it could be equity in the company, it could be part of a royalty license and things of that nature. So that's the kind of stuff we were looking at in order to be able to provide funding in a case where if you win, if the verdict comes in and you win across the board, there's actually no check attached to it.
Yeah, I've just been starting to see that. There was in the New York Times not that long ago, IPNAV, which is a large sort of patent portfolio holder, recently took an equity stake in a new app developer in exchange for financing their legal representation in an ongoing patent troll case. And I think that is really paving the way for other similar entities and funders to sort of take that both as a positive policy step and as a means to benefit in some way as a funder in these cases.
Do you think there's any potential in this space for crowdfunding, either equity or otherwise? And I only say that because I've already been asked through a couple of GoFundMe campaigns to give money to a patent troll defense case.
Yeah, there's one ongoing with the podcast patent is probably one of the bigger ones that has the sort of Indiegogos, the actual where there's no equity. I think hopefully as we see more parity come out of the SEC rules and all that for the new equity crowdfunding, that we hopefully will see that as a means to help and further the funding options for small developers.
So when we first conceived this panel, the vision really was ways of crowdfunding noble plaintiff side and defense side litigation. So the Patent Troll Defense Network immediately came to mind. We had been trying to explore ways of crowdfunding, 1983 civil rights actions. Are any of you aware of anyone out there doing anything like that? If not, why not? Are there ethical, legal, logistical implications? Because it seems like a natural fit, the natural corollary to defending small companies against patent trolls and other big companies makes sense on the defense side, but it seems to be equally viable on the plaintiff side.
So I'm not aware of any crowdfunding in those sorts of cases, which isn't to say it doesn't exist, but I haven't heard of that. There are funds, Sean split the world up into three buckets in terms of litigation funding, and I think the 1983 suit and other similar causes of action would fall more into the personal litigation finance bucket, and what he described as being in that category is probably 98% of that category, which is structured settlements, slip and falls, personal injury, med mal, insurance type cases. But there is a sliver of that sector of the industry that will look at claims that are more expensive to bring, where there could be a larger payoff at the end. So in that way, they look like commercial litigation finance opportunities, but because of the facts or the cause of action or the fact that the counterparty is an individual person and not a company, that's not the sort of case that a commercial funder would typically see. But there are funds out there that would explore those kinds of opportunities.
Yeah, I'm thinking we should create some sort of mutual fund or an index fund, just do-gooders throwing a pile of money into a pool to funnel all the public interest plaintiffs' lawyers out there. That's the vision, I think. So there's a business opportunity out there for a young lawyer.
But are you looking for a return on the investment? Because
you're looking for a way to fund the lawyer. So a lawyer isn't going to take a
but you have the NAACP Legal Defense Fund.
So on a niche.
Yeah. You've got other direct action support. That's sort of the question. If you're looking for a return on your investment, which it sounds like the folks that you would tap who would be interested in helping these folks, they're not really looking. Their return on their investment is a more just society.
Well, I'm saying some combination. Why not a 70% return? You'd be willing to take essentially a 70% return on your investment in the aggregate because you know you're doing good in the process.
All the panels fit together. At the end of the day, it's a puzzle.
B Corp litigation.
Because then you're not pushing for maybe as dramatic a return. You're looking to do a public good, right? That's the perfect B Corp space.
If you make some money back, fine.
Right.
All right, we're sort of running low on time, but I don't want to discourage participation. I know we've got One more lightning talk from an outsider, not a lawyer, and then I put this last panel last intentionally because I wanted to keep people around for the day. This is going to be a fun one. Not to say this one isn't excellent.
No, this was clearly the most fun so far, and I'm not competitive about it. It's just a fact. But thank you very much to these three panelists.
Thank you.
Thanks so much, folks. Very often, it takes an outsider with an outsider's perspective to let us know what we're doing right and what we're doing wrong and how we can change. I like to talk about how I helped work with the company that became Vonage. And when we started Vonage, we never hired anyone